Welcome to Battle with Ola, podcast with Ola now. This is a series where I bring seasoned law practitioners or legal practitioners, from Nigeria to come and share with us their perspective, their expertise, and their experience on, topical issues of law, so that you viewers and subscribers can benefit from it. And even so that I can benefit from it, because I know that so far I've brought two people. One spoke to us about property transactions in Nigeria, and the other person spoke to us about intellectual property. Even though I'm a lawyer myself, and these are aspects of law that I'm well versed in, I learned so much from them. So I'm sure that I'm going to learn a lot from our guest here today, just as you are learning. So today I have with me a seasoned law practitioner. I'm so happy because, he's someone that I've known for a long time, and I'm really glad that when I reached out to him to do this, he actually agreed to do it. So today our guest is Mr. Agbor. That's what I call him, and that's his name. So his name is Agbor Akamba Esq. So he's he's a legal practitioner, a trial lawyer, and a human rights activist. So when you see him, he's one of those lawyers that are always in the courtroom, in and out of the courtroom. Okay, so litigation is his forte, so it's his specialty. So far he has worked on 4 human rights cases against the police, which is what we want to discuss today. So this fact is very important, and he won 3 of them and lost 1. Quite candid, I'm sure he will explain to us along the line. But what we really want to talk about today is enforcement of fundamental human rights. It's a special procedure under our laws in Nigeria, and it's governed by the Fundamental Rights Enforcement Procedure Rules. He's going to talk more on that. I've brought him because 2 different people at 2 different times have asked on the channel that I should talk about enforcement of fundamental human rights, and that I should explain the process, for enforcement of fundamental human rights and all. So I thought that why not bring someone that does it in real life, someone that has, a practical perspective, a practical point of view. And that's why I've got Mr. Agbor Akamba Esq today. So Mr. Agbor, we are so glad to have you here. Welcome to Battle with Ola, and welcome to this series podcast with Ola. So you are the 3rd guest in this line in this series, and we're excited to have you here. So say hi to our viewers.
Okay, I'm very honored to be here. Like I said to you, that I'm very grateful to share the spotlight with you, and in the field with which we've been through. I know as we go on, we have a lot to gain, both from the other side and from this other side. Thank you very much.
You're welcome, sir. So we'll go right into it. We want to talk about the enforcement of fundamental human rights in Nigeria. So, Mr. Agbor, what exactly is fundamental rights enforcement?
Basically, what we are seeing in essence is that first, you must have those rights. Second, it is that those rights have been breached one way or the other. And like we said in law, that when there is a right, there is always a remedy. So you are looking for means to remedy the breach of your fundamental right. So in essence, the Constitution is the platform with which, when your rights are abused, you go ahead to see, how do I enforce this right? So number 1 point we look at, you have the right. Has that right been breached? What does the law say about when the right is breached? So that is what it talks about. The steps you now take to remedy that breach is what we now talk about enforcement. That is the procedures that are involved.
So that is, you have told us that the right must be existent as of first importance. You have to have the right, and then the right must have been breached. You want to add anything to that before we go to the next question?
Okay. Established by law, especially the Constitution, like we have in Section 35 that says that liberty, right to liberty. So most especially, it is right to liberty that is breached. That is to say, when the police stop you or detain you, it simply means your right has been breached. to a point, especially even though you've committed a crime and the detention is outside the days the law allows you to be detained. It presupposes that your right has been breached, and the law says that if you feel that right has been breached, or that right has been breached, or you are thinking it is being threatened to be breached, you have a right to approach the court to enforce it. So you must first and foremost have a right. That is the position of the law.
My next question is, what are the laws that govern this set of rights in Nigeria?
Basically, for fundamental human rights are provided under the Constitution of the Federal Republic of Nigeria. We also have the African Charter Act that provided for the fundamental human right, which, with respect to Section 12 of the Constitution, has been domesticated in Nigeria. We also have a United Nations human right that talks about this law. So basically, for Nigeria, the Constitution is the basic ground with which this law are built on.
Okay, great.
Are you there?
Yes, I am.
And in the Constitution, they are in Chapter 4 of the Constitution of the Federal Republic of Nigeria.
Yes, Chapter 4. Yeah. So yes. I want to ask a question in this manner. Okay. You know that if someone should slap me now, I already know that that's an assault, or it's an assault or battery now, either of the two. Yes. One is apprehension of arm and one is the actual arm, assault and battery. Yes. I already know that if someone slaps me, that has happened. And then I know that it's a tort that I can sue. How do I know that my fundamental right has been breached? I know you talked about the right to liberty, like that's the crux of this procedure. So how do I know that it's been breached? What will happen to me that will make me know that, oh, my fundamental right has been breached? I need to file for fundamental right enforcement.
Okay, basically in our society, because of the literacy level which we have, many people who don't really know when their right is breached, except or otherwise when they consult a lawyer. And second to that, we have this African mentality that, I'm sorry to use that word, if it is a negative word, African mentality. With respect to that, we have a future to meet, so we wouldn't want to fight. But basically, before a complainer or an applicant will know, it is either when it involves a lawyer, and it normally happens in the police station. How? Okay. A person may be arrested. Okay, take for instance, I told you there's a matter I handle. What was that matter? Somebody was to project a film, and in the course of it's a contractual relationship. So most times these things arise from a contractual relationship. What happened? He was to do a film. He did the film, and the other person felt that the film was not adequately done. So for him to recover his money, instead of him to sue for breach of contract to recover his money, he now took the matter to the police. The police were now forcing the other party to come and pay. Now, when a lawyer is involved, most times, before an applicant knows, it is when a lawyer is involved. That is when the lawyer will tell him, your rights are being breached. Because as in this case, they were taken to police station, they are detained them for 4 days. After that 4 days, they came and they said they should settle, which is against the Section 32 sub 1 of the Police Act 2020. That says that police should not arrest on mere contractor or civil matter. Mm-hmm. So on that basis, they were now forcing them to come and work to settle. And 2 days, 3 days, they were threatening them. So to that effect, when they contacted me, I told them that their right has been breached. Fundamental human right, the right to liberty has been breached for detention. Above all, that the question in which they arrested them based on is a contractual matter. It's not a matter with which police have right. Mm-hmm. Should I go on?
You go on, sir.
Okay, so it is not a matter of which police have a right to arrest them. So on that, while the police were calling them, I told them they should not worry. I know what to do. So I had to file the fundamental process, file in the High Court, then serve the police. It was when they were at the police, they've served the police, and realizing that we've taken the matter to court, the police were running here and there to arrest them. So normally, that is where it begins. So some people will not know. Sometimes it is the longer arrest. Okay, you are supposed to be at the law says 24 hours, you release them or take them to court. But the police, because of what they get, sometimes the money, the bail money, or they want to force you, because sometimes people undersign these undertakings at the police station.
Yes.
And the position of the law is that where parties are resolved their agreement to settle, the police should remove their hands. But the police will want to go ahead to say sign undertaking, and below the undertaking, they will say, if I fail to honor this undertaking, you can take whatever decision against me. All trying to frighten the unlearned applicant or accused or whatever. So when a lawyer comes here, it is only when a lawyer comes here, except the learned ones, that will say, okay, your rights have been breached. That is where the process begins.
Okay, great. So once I find out that my right has been breached, what is the next thing for me to do?
Okay, in a normal setting, is to approach a lawyer. Okay. Write to the police. Sometimes we start with like writing a bill application to the police. In another sense, like a matter I handle, take it like this. Let me use this to clarify issue. People went for a fishing party. They pour chemical in a stream and they dive in. When they dive in, one of them died. And you will know what will happen. The others ran away. Now, when police went to arrest, they did not arrest the culprit. Remember, they now arrested in lieu, which the administration of Act or law, depending on this, has said that there should be no arrest in lieu. This, yes, you should not be arrested in place of your brother or your sister or anybody, even husband and wife. It is just like the Bible says, it is the sin of the father, not the sin of the uncle or thereabout. I hope I'm not bringing Bible into
It's allowed. It's allowed.
Okay, so just like the Bible says, it is he who sinned that will bear his sin. So the law has also come to say that it is the person who committed or suspected to have committed a crime that should be arrested, not the brother. So in this case, the brothers, one of the brothers was an imbecile, and they arrested them, put them in the police station for 8 days. While I came in to, bail them. After bailing, I told them that these people are not involved. The next thing, the police took the matter from a local area to the head office, detained them. So in that process, I filed. So in the normal process, it says that 1, they are not a suspect. 2, the law which the police brought them, they are, if we should say, they are free from that law or not guilty. So that is where the process begins. So you must have that right. So in that case, when I filed, we took the matter to court. I went to court. They say I should bail the young man because the brother, it was a distance of 3 hours from where the brothers are. I told them that a lawyer does not sign for, it does not surety. We only recommend surety. They said I should write a letter before I bring the person out. So I had to write a letter. And thereafter, when I brought him, as I was going, the process was already in the court. It was during that COVID-19 period, exactly 2 years today, I think 1st of April 2022. So it was during that process. The process was served on them. And when the judge went through the fact of the case, it deprecated the act of the police that why should they arrest in lieu? They said they should go and look for his brother. So sometimes that is where we have issues. The Nigerian police will arrest you if they did not see who is the actual perpetrator. They will now say, go and look for the person. It is not the right of the accused to look for any thief or whatever or any suspect. It is the police duty.
Of the police.
Yes, yeah. So it is the police that is supposed to look for them, not you that is accused or arrested and say, go and look for the person. If you do not bring the person, we will detain you. It's against your right because the law actually says it is the person who commits a crime that should be arrested.
Exactly.
So sometimes this breach normally arises in issues of this nature. Now, there are some other issues. The position of the law says if you know that the gravity of the crime in Akpan and the state, the court says that if you know that the gravity of the crime is serious, then the police should not be lackadaisical with approach of prosecuting the matter. So if I am to be arrested and prosecuted, even for a crime I have committed, if the police fail to prosecute me as at the right time, now taking 2 years, 3 years, 4 years, before they go to court, I have a right to go to court to say my fundamental rights have been breached. It will not, it has been breached upon. It will not be dependent on whether you are guilty or not guilty.
Okay.
No,
I'm happy that you mentioned that. So this right is not just for the innocent.
No, it's not for the innocent. Assume, quote and unquote, until the court pronounce you guilty. At that period of time, prima facie, we are still saying you are just a suspect. So if a person has committed a crime or alleged to have committed a crime and trials are not begun early, he has a right to go to court and say, I'm being detained. Let them prosecute me. If I'm found guilty, fine and good. Let me serve my due sentence. But if you are keeping me for 10 years, 20 years, like some people are languishing, insane, because some will tell you their case file. I handle a matter that for 4 years, they could not trace the case file. So his right not breached, they have been breached. So I had to come in, stand in, sue the police and the DPP that we have until we are unable to find. And I asked the court to strike the matter out. What is the essence of wasting his time? So those are the rights. So sometimes it's not about the guilt. It is about whether the police or the state is able to carry on expeditiously, because under the administration of criminal justice law says that one of the purpose of that law is to correct the effect of long stay or congestion of prison. So if a matter is brought before court, immediately matter should be tried if the person is found guilty. So if you now keep him, the position of that law has been failed.
Okay, thank you so much.
Yep.
So I want to ask this enforcement of fundamental, you know that what is common and what most people know about is bail application. Yes, there's administrative bail, there's bail at the courts and all of that.
Yes.
And then there's bail pending appeal and all of that. I have a video on bail. I'll leave the link to it in the description box so that viewers can watch it if they haven't yet. So what I want to ask is that this enforcement of fundamental rights, is it for a special set of lawyers? Like, is it, you know that in Nigeria today, you have, if you were talking about IP, some lawyers are just specialized in intellectual property. Some lawyers are specialized in corporate commercial. So this fundamental rights enforcement, is it for, if I'm a person whose right has been infringed upon and I want to enforce it, can I go to just any lawyer, or do I need to look for a lawyer that is specialized in that?
Okay, I will answer the question in two ways. In two ways, in the sense that generally in Nigeria, you know, our law is based on specialty, just like we talk of our learned senior Falana and the Ganifemia, who were specialists or thereabouts. So it is something you can meet every lawyer. But like we say, it is not every lawyer that can handle it, in the sense that some have not been going through the process. So if you meet a lawyer that has not gone through the process, like you are starting it from the ground. But if it is a lawyer that has been going through the process, it will not take you a time. So what I will say in that sense is that you can meet every lawyer, because it is expected that every lawyer should know the law that guides fundamental human right. But some lawyers might not want to go to that aspect. So they will tell you, okay, this is the line I practice. So that is how it is. But somebody who has been doing it over and over is somebody that sometimes we recommend, just like what you are doing now. I don't know much about it. So if you want to meet me, except I have to take you through the training process or ground process, that is how it is. But in a normal way, every lawyer ought to know it. But if one is not practicing, that is where the problem is. So on the one hand, somebody can meet a lawyer, because sometimes you cannot immediately now meet Falana or meet me or meet another person. So we always start from somewhere.
Yes.
We always start from somewhere. So before the Falanas become known or renowned for fundamental right activists, is that they started from somewhere. So a person can meet a lawyer, and the law, because it is the lawyer that will tell him his right. Like I say, in the process of bail, where the law is breached, the lawyer can start from there. But I want to tell you that some people wouldn't want to go forward. They say, lawyer, you don't do now. Sorry for bringing in that language, but that's what we always have here. Lawyer, you don't do, you don't pay me, you don't pay me. Even when you are telling them their rights are breached. I want to bring a case to you in Faith Okafor and Lagos State. She went out on environmental day.
Okay.
And they arrested her, you know, that, how do they call those improvised courts?
Yes,
so
yes.
They even find her a mobile court. They even find her guilty for breaching the environmental law. And After she paid the 2,000 naira or thereabout, the lawyer said, no, they've breached your right, irrespective, because the environmental law, so to say, is not a law that was made by the House of Assembly of Lagos, because it breached the right of, it breached the section 35, freedom of liberty. That law says you can move everywhere. I mean, right to personal liberty. So her right of personal liberty was encumbered, and that law was not made by the Lagos State House of Assembly. With respect to Section 4 of the Constitution that say that is the inconsistency rule. So if Lagos State, with respect to that, if Lagos State is now making another law that breach on her personal liberty, what about the position of the Constitution that says she has a right to move anytime, anywhere, except in curfew period? So she went ahead, pressed on up to the Court of Appeal and Supreme Court, and the Supreme Court heard that she was right, that was her right that was breached, and the Lagos State should compensate her. So that is it. Wow. But ordinarily, when she had paid the 2,000 naira for mobile court, what happened? She would have gone on and said, well, I've paid. But it says that right was, that law, environmental law, was inconsistent with the Constitution. And wherever inconsistency exists, it is not avoid.
Inconsistency is null and void.
Yes.
And of no effect. So I'm happy that you mentioned this. So now what I want you to do briefly is to differentiate between bail application and enforcement of fundamental human rights. Because now you have said that ordinarily, after you have secured the release of some suspects, they will say you don't do lawyer. So are you now saying that you can secure their release without having filed this procedure, or that once after securing their release, that's when this procedure will come? I want you to shed some light on that aspect.
Okay, like in the first case I mentioned with respect to the fishing party.
Yes.
It was while the person was still in police bail. I've applied for the first bail at the divisional level. They granted the bail. They now took the person to SID, that is at the state level, at the Commissioner of Police level, not the DPO level. Now, as at the DPO, the Commissioner or CIB level, the state CID level, bail was not granted. I went straight to the court and filed the fundamentals because first they've granted him bail. So in certain circumstances, you apply for bail first, and they grant the bail, believing that the matter will end there. But if it does not end there, you can go ahead. Like the second case I mentioned of production of film, I went there, they granted the applicant in a nutshell in the first instance. If bail is granted and there is no further exercise of police power or thereabout, you might not go ahead. Just like I was using the case of Faith Okafor and Lagos State, that though she paid the fine, she was fined by the mobile court. But when the lawyer saw that her right of personal liberty, are you still there?
Yes, I'm with you.
Okay, her right of personal liberty have been breached against the Lagos State governor environmental law, this thing. So she still went ahead too. So in some instances, after bail application, you can decide not to go further. While in some certain cases, even after the bail application, you see that your client will not be left off the hook, and you've explained to the police that this matter is not a criminal matter. Let me give you instances of another case. The case with which I told you I lost. It was also a contractor. The case arose from a contractor relationship of digging a borehole. The man went there, dug a borehole in an environment where the soil has no rock beneath it. And the agreement further said, okay, go to another place where the person never knew there was a rock. So after he dug and discovered that there was a rock, and I was okay, this contract, from a legal point of view, that contract has been frustrated. It was for parties to sit down and look at whether there are going to be refunds or thereabout. The other party now felt because he has a hand with the police, went and hired police to arrest him. Now, he was granted bail, given undertaking. But the police were now calling him off and on to come and execute the undertaking, that is to refund money. So when it comes that, to refund the money, the contractor's sum, a contract that has been frustrated, so to say, the police were now threatening to arrest, threatening. In short, they even bundled him at a particular point. They bundled him by their heels to Akure. You can understand that. Then we now look at, okay, what else? They've not filed the matter in court. Look at that. They did not file the matter in court. So they were now threatening. So we had to go to court and say, okay, our fundamental rights have been breached. Yes, we're granted bail. If they know we have a case, why didn't they take the case to court? So we went to court. Though in that case, the court did not give us, when I say I lose, is because they did not give us compensation.
Okay.
But my lord always said they were not compensated. My lord said that what I was looking for is for the freedom of my client. And insofar that he now gave order that my client the police should no longer threaten my client, that if they have a matter within a week, they should file a case in court. That was in 2021. Till date, they've not filed a case in court. So where I'm saying I lose is because we were not granted compensation, unlike these other 3 cases.
Can you imagine? Viewers, I'm correcting my introduction. Our guest today has done 4 cases and won all 4 cases. Don't mind him. He said he lost us because of money. No, we won't take that. So you won all 4 cases as far as right enforcement is concerned. That's great.
So the first one, they awarded us 2 million.
Okay.
The second one, 250 apiece. That's 500,000. So the third one, they did not award us any money. Now, I want to say a little something, except we want to continue, but I want to say something. I wouldn't know whether you have it in the question section. With respect to, sometimes, with respect to the Constitution, enforcement of fundamental human rights is just the beginning process. I haven't gotten the judgment. Another Herculean task to climb is enforcement of the judgment. Like the 2 million they awarded us now. Under the either section 85 or thereabout, it talks about of the Civil Process and Sheriff Process Act.
Sheriff and Civil Processes Act.
Thank you. It says that where the government, where the respondent is a government officer or thereabout, I used to say, for you to recover any money from them, you must first and foremost seek the consent of Attorney General of the Federation or the state. In the first instance that they were awarded in our favor 2 million naira, the case is still in court because we wrote to the Attorney General for several times for them to give consent. They are unable to give consent. So we now had to work to take a mandamus to enforce them to give consent. So we are still at the Federal High Court now. Okay. In short, as I tell you, that matter was meant to be for ruling on the 26th of 2021, April. But because of the transfer of judges, so it could not go on. So I had to go and refile for fiat for them to bring the judge to come. So sometimes you might win the case, but to get the money, because Attorney General might not give consent. So after that, what we're trying to do is that we'll pursue the Attorney General. If the Federal High Court give us the power and command him to give consent, the moment he gives consent, we now sue the central bank because it is our understanding that all police funds are with the central bank. So we are looking for where to get, we are looking for where to get our money so we can begin a garnishing proceeding against them. So that is how it is. So sometimes that law, the Constitution gives you with one hand and another law takes it with another hand. So sometimes you might enforce your rights, but to get the benefit of your judgment, it becomes another Herculean task. And like one professor said, he said it takes a diligent lawyer in enforcement of fundamental human rights to have both his judgment and his money. Sometimes you might have the judgment, you might not have the money. That is,
in fact, it's really an Herculean task because I can imagine you're filing so many things just to enforce one thing. Can you imagine? So yes. I can understand how when you were saying initially that for some people, in the case of Faith or Kafu, some people would just say, yes. Oh, let me go. Like lawyer, I don't do. So I can understand why some clients will say lawyer, I don't do. Because, I mean, you filed, you've gotten the judgment. Now to implement it is the problem. And I know that that's one problem that we keep having with the police. Sometimes, even if it's not for them to pay. Because I know that one of the earliest judgments that I got, in fact, was the year that we were called. No, the year after, the year after. So I remember that we did this matter. It was a police officer that was the nominal complainant, and then he decided to withdraw the matter. The court ordered that the goods that were detained from our client's shop should be released now to get the goods back, because the goods were detained at the police station. Sets of televisions, home theater, electronics, because the guy was selling electronics, and then they accused him of receiving stolen property. They detained a lot of goods from his shop. Then he went to court. We went to court and all of that. When we got to the police station, they had to tell us that that's the judge's own. That now, for us to get those things out, we will now follow their own process. So we are the IPO will be settled. Then the supervising officer for the IPO will be settled. So many things. You have to go to the OC Legal's office, go and talk to him, appeal to him. So we're going from one office to the other. So I know how difficult it can be, relating with the police. And especially, I'm glad that you mentioned garnishing their account at the end of the day. Next guest I'm going to bring is going to talk about garnishing proceedings, because I've observed that these days it's almost like a wild goose chase. Because now banks are also taking to lying. When you get the court's order,
a judgment,
that they should declare what's in their account. At the end of the day, they'll be declaring 1,000 naira, 58 kobo.
The one I had a judgment recently, and I threw the garnishing proceedings and tried to execute it. Do you know what UBA brought? It was the day they served them the judgment that they now brought to reflect the account. And they said that only what is left in his account was 3,000 naira. I was like, what? So I now have to file a counter to that affair. I say they should update us with 6 months of the 6 months, so that we should see the years of the bank statement if actually there was no money. And I'm waiting. The moment they cut, if there is anything toward that, because the bank is most of our institutions are working.
Yes, they are complicit. They would have tipped off the defendant or the judgment debtor. So it will move the money away. So they make all these procedures useless at the end of the day. But let's not digress too much. Let's come back to
deviate
enforcement of fundamental human rights. So what courts have jurisdiction over this procedure?
Okay, basically it is the state high court and federal high court.
Okay.
But in some instances, some people will, depending on who is involved. So, but it is the state high court and federal high court, not magistrate court, not even election petition tribunal or the National Industrial Court. It is the high court that has sole jurisdiction for fundamental human rights. Okay.
So from the perspective of a lawyer, when you want to file, what are the processes that you will file?
Okay. First and foremost, let me take, first and foremost, what you do is it's just like a motion. Okay. You prepare a motion. After a motion, we have affidavit in support of the motion. We have a statement of fact. That is, a statement of fact is to relate the fact of the case with respect to which you are filing.
Accused was detained and all of that.
Yes.
Okay.
Then the affidavit, in some instances, like the affidavit in support of the motion, will be that either the person is in detention while a relative of his is filing the counter affidavit. So it is that relative of his that will now relate the fact in the affidavit. While in another, after that, you now address the court. So those are the address. Okay. Your written address. So it is moved like we move a normal motion on notice. That is how, but the only thing is you state the position of the law, the brought under order, so. That's what you state. After that, the fact affidavit in support, and if you want to refer the court to the, you say in paragraph so that the statement of fact stating what is there. Thereafter, the address. Then, in some instances, the court might, because sometimes you would have filed, and then cases are reported, you come to see other authorities. That is where you come to say you want to adumbrate. But sometimes they give you time to adumbrate. Sometimes they say, what you want to adumbrate, is it not already in the in your address,
Written
protect the
address.
record where it is in your written address. So that is the process. It's just like a normal moving a motion, but they would not call it motion. They say trial. So it means that, or hearing of the application. That is what is involved.
Okay. So the originating processes are a motion, and then the affidavit in support, statement of
of the
facts,
motion, yes.
and then the written address.
And then the written address, yes.
Okay,
yes.
great. So what are the prayers that you ask for in the motion?
The first is a declaration.
Okay.
That is, you ask like the applicant a declaration that the act of the respondent. So if it is unlawful arrest, you state the particular days they arrested and detained him, that the court should declare that that act was unlawful, unjustified, unconstitutional, and therefore breaching the rights of the applicant. So having stated that, because the court, before the compensation or award is, the court must first and foremost hold that he has a right, that the right was breached. So it is after that you now declare that where the right, the court, a declaration that the act of the respondent should be declared in arresting the defendant, holding him, either if it is a case of a contractual matter, is unlawful and therefore breach the Constitution. Thereafter, an order of the court commanding the respondent to unconditionally release where they have not released him, or charge him to court for court to release him. After that order, you now say, where the court has found that his right has been breached, the law says that he is entitled to compensation and apology. So you now make an order of apology or an order of either 20 million naira, because the one I did, I said 25 million naira, and they only gave me 2 million naira. So it is an order of so. And another order that, so those are the prayers you are going to make. And at the end, the omnibus order for such order or any other order. That is.
In fact, you have done justice to this. So, what are the results? That is, what is the order? What are the orders that the courts will now make after you have moved the motion?
Okay. Once the court has held that there was a right that was breached, the court will now move the order. First and foremost, the court will declare the act of the respondent as being unlawful.
Okay.
And thereby have breached the constitutional right of the applicant. Having found that the right has been breached, the court will now go ahead to say that since the right has been breached and the law says he's entitled to compensation, the court will now look at what you asked for, either 400 or whatever. But the court has discretion in the award of damages. So like I told you, in that case, I asked for 25 million naira and the court awarded 2 million. The other two cases, I asked for 25, and the court awarded 500,000. So that is how it is at the discretion of the court to award. And in this case now, opportunity will not allow us to bring relief for special damages where if there is payment of lawyer or thereabouts. So it's only the general damage that the court will award. So it is on that base that the court will award.
Thank you so much. Before we round off, someone asked a particular question that you should do. He said, please do a video on how to adopt fundamental human rights application. So I want you to, can you give us like a demonstration of adopting the motion in courts?
Okay. Though I've pointed it in between, but look at how it is. When they call the case, the court will ask you to announce your appearance. You announce your appearance. If you are the applicant and the respondent will announce, then the court will ask you, what I say, my lord, we have our application is, our case is for hearing. Okay, move your motion. Like I told you, I say it's just like a motion. My lord, application was brought pursuant to section order of the Constitution and others, and others of the fundamental right enforcement procedure. Application is dated. So sometimes you can decide to move in terms. We move in terms of the application.
Please
or
don't
the
move in
court might.
terms, because I suppose that this
Okay.
person is a new week. So
Okay.
let's
So
move in terms.
what you will now do is, my lord, application is dated. So let's use today for a case study. The application is dated to the 4th of April 2021 and file same date.
Yes.
That is identification. It's a motion of notice brought pursuant to the Fundamental Human Rights Section 35 sub 2 and Order 2 of the Fundamental Human Rights Enforcement, and under the inherent jurisdiction of this court. My lord, our application is supported by a 12 or 2 paragraph affidavit sworn to by the applicant, if the applicant swore the affidavit as the deponent, or sworn to the applicant, who is the deponent. My lord, the fact of it in paragraph we commend the court to go through that paragraph. Thereafter, you go to the next one. My lord, application also has a statement of fact, a statement of stating the fact of the case in support of this. You go further again. My lord, with following the rules of the court, application also have what? The written address, being our oral submission to support. We urge the court to move and to grant our application. What application is the court going to grant? On your motion paper, what you ask, a declaration for this, a declaration for that. That is why what you have. So after that, if you have adumbration, my lord, we seek to add so and so authority to enable my lord to do justice to this case. That is our application. Now, if the respondent file a counter affidavit, saying the court, because where the police will always defend, you will always have a counter affidavit. And if you also had a further affidavit, when they file a counter, you have a right to reply. So you will move them all together. You will say, my lord, also the respondent also file a counter affidavit dated so, in which we respond to by filing a reply or a further and better affidavit to counter their process. So you join it together. If there is anything you want to react to the affidavit, maybe the affidavit did not follow section 115 of the Evidence Act, that if there are some prayers made in the affidavit or argument made in the affidavit, so you follow that to counter it. So what I was saying is that you move in, if there is a counter affidavit, you react to the counter affidavit. And if you file a further affidavit, like in the recent case I did, the lawyer to the respondent said that we doctored our statement of fact with respect to their statement. We needed, they gave us facilities to defend the case, because it is when we filed, they went to court after we filed. So we now use the facilities with which they avail us to now prove to the court that the court should look at it to see that it was a stricto sensu a civil matter. So the lawyer now reacted to the fact that we doctored those papers, that we did not have a certified true copy. So we had to counter and say, okay, there is a present position of the law that public documents already attached to our affidavit are already what? Evidence. They have gone through the process of evidence, just like if you now attach, although there is still a question whether if it's a different religion, the paper is attached to the affidavit. So then in that position, the law says that if it is already attached, the subsequent action of having to go through section 104 of the Evidence Act with respect to a certified true copy of the public document would have been done away with. So when you say we doctor it, we have to react with that. That the authority, the law is that when a document, even if it's a public document, that is attached to an affidavit and it has been marked as a receipt, so and so, the process of making it affidavit, which ordinarily would have sought and obtained other paper for certified true copy and whatever, has been done with. So you react in every other thing, you bring other the counter affidavit, you react under it. So after that, you ask the court to grant the application as free. So the court will adjourn or hear from the other party will now also move their own counter affidavit and the other paper they have. Then the court will now adjourn for judgment or ruling. That is how it is. But permit me to add one thing. Now, in the enforcement of an
fundamental human right, there is no joinder of application. They don't say any person. So it is some people bring, you might have a case of a similar transaction, but you need to file the application differently. In a situation where 10 people are arrested for a similar transaction, you cannot file one application to cover them all. Yeah, so but what you can do is you can file individual application and later on you bring application to consolidate them. So because the law is for any person, and any person, you know the law that express mention of one thing in the exclusion of another. So some people make a mistake where there are two people, they bring double, the court will strike it out. The respondent will raise an opposition that the application is not proper before the court, and the court has no jurisdiction because the law says that it's any person, not two people. So that is what I want to add. In case anybody has an issue like that, they should split the application. Thank you very much. Now on the first on Facebook, you reach me at arico.e.agbor.facebook.com. Then on LinkedIn, you will see Agbor Akamba Esq. That is LinkedIn. And on email, I have two emails. One is jagbor75@gmail.com. The Yahoo one is eanyam@yahoo.com. Thank you. Bye. All right. Okay. Thank you. All right. Bye. Okay.